There's an irony in commercial disputes. We often feel this sense of urgency, this need to rush to action in the early stages of a dispute, and yet the process for resolving that dispute may take many months and indeed possibly years. The problem that creates is the decisions we make early in a dispute are the decisions that set the foundations for the outcomes we'll achieve and the process, the costs, the steps that we will take in resolving that dispute. The risk is that without calm and considered reflection, we make decisions that bake in unnecessary costs, unnecessary delays, and set us up for poor outcomes. We might rush into the process. We might issue legal proceedings too quickly, and then we feel as though we're stuck on the tram tracks of a proceeding, and it's the proceeding itself that drives our decision-making on resolution, rather than the freedom to explore alternatives to effectively resolving the dispute. I often saw this in my practice as a barrister, where the real issues in dispute between the parties, the very things that will lead to an effective resolution, are not identified until many months into the legal process. And the problem that we need to tackle is, how do we slow down the decision-making in the early stages of a dispute? How do we set ourselves up? How do we position ourselves to obtain the best possible outcome in a dispute? An important way to avoid the problems that come from urgent decision-making is to take the time to establish the foundations for a valuable relationship with your lawyer. And to do that, the early engagement with your lawyer, you need to focus on understanding three things: what to prepare for that early stage engagement, and what to expect, and what to learn. I'm going to take you through each of those three things to help you set yourself up for that valuable relationship. What to prepare. There are really 5 things you need to prepare. First, you need a clear understanding about your objectives. You want a sense of what you're trying to achieve. 2, you want to understand the problem. You want to articulate the dispute as you see it, in your words, as you've experienced the dispute. 3rd, you want an understanding about the impact this problem is having on you and your business, and the impact resolving this dispute, or indeed failing to resolve this dispute, will continue to have. 4th, you want to understand the resources that you are prepared to bring to bear in order to resolve this dispute, and you want a clear understanding about the constraints that you expect to face. And 5th, you want an understanding and be able to clearly articulate what you expect from the relationship with your lawyer and what your lawyer expects from you. I'm going to focus now on just 2 of those 5 things. And in my experience, it's these 2 things, the way in which we think about our objectives, the way in which we articulate the problem, that often cause the most difficulty. The first is objectives. Thinking about and conceiving of your objectives is not just thinking about the outcome you wish to achieve. It's not, for example, just saying, I want to receive X dollars, or I only want to pay Y dollars. You need to think about your objectives in terms of the broader things that you seek to achieve. Outcome is one. You would want to consider timing. How important is it to you to resolve this dispute in what time frame? You need to have a good idea about how important timing is. And there's a whole series of other factors to consider in relation to your objectives. How important is maintaining the relationship with the person you're in dispute with? How important is confidentiality? Is it important to keep this dispute private, or is it important indeed to make sure others are aware of this dispute? How important are the principles that this dispute creates and establishes for your relationships with others, for example, relationships with other similar suppliers? So have a more nuanced perspective on your objectives than just, I want this particular outcome. Number 2, the problem. It's really important that you can articulate to your lawyer your understanding and perception of the problem, of the dispute that you face. Now, this is important because we often approach a dispute, a legal dispute, as though we don't really have the language to understand the dispute unless we are in the lawyer's shoes. Now, that's not right. The first thing we need to do is we need to understand the dispute as those in the dispute are experiencing it. It is the lawyer's job to then craft the articulation of that dispute into a particular legal framework. But the initial understanding of the dispute is your understanding. It's your experience. And so what I want to do is give you a framework for articulating the problem so that you don't fall into the trap of thinking and being constrained by the need to articulate the problem using legal language. Now, in my experience, every commercial dispute follows these 4 key factors, and it's critical that you are able to explain and understand them. Number 1, what do you say the other party did wrong? Why was it wrong? What loss did it cause? And how can it be fixed? Now, of course, if allegations are being made against you, you want to run through the same 4 questions. Now, if you can articulate your problem in those 4 simple steps, you're giving your lawyer the perfect foundation to be able to articulate the legal arguments and the legal consequences that flow from those facts. What to expect and what to learn from that early stage engagement with your lawyer? Well, there's 3 things. Firstly, you want to have confidence that your lawyer understands your objectives. You want to make sure you're on the same page. Secondly, you want to understand what's missing. What information, what intelligence will you need to be able to make informed decisions about the most effective pathway to resolution? You want some sense of what needs to be obtained and how you will obtain that. And the third thing is you want a clear path for the next steps. Importantly, when thinking about next steps, what you shouldn't expect is a solution. What you shouldn't be provided with in that early stage meeting is a quick answer, a quick path to resolution. Now, this is going to be counterintuitive. We often go to our lawyers expecting there to be certainty, expecting to receive an answer. The problem with that is the answers come from reflection. The answers come from careful consideration. The answers come from identifying the information that you need to make informed decisions, and the answers come in the form of options for resolving your dispute. And finally, to avoid the problems created by urgent action, take the time to get different perspectives. Talk to different lawyers about how they understand your objectives and how they understand the problem you face.